Hello, everybody. It's Dave Neal, stand-up comic, host of Bachelor Nation News, and we've got the closing statements in the Clayton Echard v. Jane Doe court case. It was an injunction against harassment. I've never listened to this before. This is my first time listening to it, sharing it with you guys as we are looking at public records from the Arizona Superior Court. This is not sealed. This is unsealed, which means the public has a right, and some might say a duty, to listen, even if some people don't want that to be the case. I'm going to share the closing statements with you, and I do want to say, for those that want an update, we have had an order of protection filed against me by Jane Doe. That means she attempted to go through the court system in the Superior Court of Los Angeles County and attempted to have an order of protection placed against me. That order was denied. She is still going forward with an injunction against harassment on me, claiming I am harassing her. And now we have threats that she is going to sue me for defamation. Those are important updates to give because a GoFundMe was created on my behalf. It quickly, within one day, raised $6,000. We have not touched the money, which means I am able to refund it. But it looks like now I'm going to need at least a $10,000 retainer for the legal fees to cover all of the litigation that is happening. Even though I'm not in trial, there are a lot of things that the lawyers had to be caught up on that's going on. So I don't even have access to this GoFundMe. It's not turned back on. I will let you know when it is turned back on because, like I said, we paused it. I don't want money I don't need, but because I'm the only one covering this court case, I'm being accused of harassment, which is something I would probably take to the grave to say that it's not my intention. My intention is to show the public what's going on here and show the trial that everyone's been watching. So we're going to share the closing statements. Yesterday we shared. Oh, wrong image there. Yesterday we shared the cross-examination of Jane Doe, and here's what Clayton's lawyer has to say, and then I'm guessing we're going to hear from Jane Doe's lawyer after that. Again, I'm just going to hit play. We're going to listen to it. Where I pick up is 1 minute before the closing statements begin. This is where we finished off yesterday. I know it's a lot to listen to, but this is kind of the melee that's going on, a fight breaking out between both sides and the judge stopping it and saying, we're moving on to closing statements. Have a listen.
Here, and again, I mean this with all due respect, but Ms. Owens has a pattern of behavior here. She has previously made identical allegations in another case. The exhibits that I have today, as supplemental exhibits, all support that the statements she's made to Mr. Echard are almost identical to statements made to Mr. Gillespie in 2021. This is highly concerning behavior. She has now perjured herself on several occasions during testimony, and I am not being given the opportunity to show the court the documents to support that she is lying under oath.
I have proven my pregnancies and had my records sent to Mr. Echard.
Okay, Ms. Owens, Ms. Owens, we're not testifying right now.
I'm sorry.
So that is the judge telling Jane Doe, it is not your turn to talk. Clayton's lawyer is saying they have not been given the chance to show the evidence to prove that Jane Doe is lying and committing perjury. That's what's going on.
Even if it was true that Ms. Owens did that in the past, which we are denying, but even if it was true, that has no relation to this specific case. Just because she may have done it before doesn't mean she's doing it now. And we have presented evidence showing that she is pregnant. We have presented evidence showing why she is.
That's false.
We're going to do closing arguments now.
All right, so then there you've got Clayton's lawyer saying, objection, that's false. And then the judge says, you know what, go to closing statements. I'm late for lunch. I've already made my decision, right?
So whoever wants to do a closing argument, Ms. Arena, go ahead.
Your Honor, this is a clear case of harassment. The court has seen through all of the exhibits submitted by Mr. Echard and the additional exhibits that we presented today that the parties had an encounter in May of 2020. Mr. Echard did not have sexual intercourse with Ms. Owens. Shortly thereafter, Ms. Owens began claiming She was pregnant with Mr. Echard's child, with an alleged child. Mr. Echard repeatedly, from May to today's date, has pleaded with Ms. Owens to stop contacting him. He has blocked her number on several occasions.
I could tell you this, too. I've asked the same person in question to stop contacting me, and I received 2 lengthy emails yesterday. The other thing she does is she puts email trackers into her emails to say, look, they opened the email. And it's like, yeah, telling someone to stop emailing me doesn't mean I'm not going to open the emails. I'm sending those to my lawyer. You know what I mean? So I can understand how Clayton feels like this is harassment, because I feel similarly.
And she gets a new number and or uses an app to continue contacting him. It has not stopped. Mr. Echard has lost job opportunities, speaking engagements. He has suffered extreme emotional distress over these claims that are baseless and over her repeated outreach attempts after pleading with her to stop. This is the definition of harassment. The court's well aware harassment is defined per the statute as a series of acts over any period of time that is directed at a specific person and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses the person and serves no legitimate purpose. Ms. Owens has fabricated a pregnancy now twice on 2 separate occasions. Mr. Echard is the second victim of this. She has provided no medical records to support that she is in fact pregnant. As the court saw, her Exhibit 46, Your Honor, is not medical records to support a pregnancy. It is merely, and I'd like to draw the court's attention to this, it is a picture of a test completed at Banner on June 1st of 2023 regarding HCG. It does not say it is a positive pregnancy test. The next page, Your Honor.
Oh, I'm sorry.
This is not your turn.
I'm sorry. It does. Okay.
So then Jane Doe gets scolded by the judge to say, it is not your turn. An this hormone test that she speaks of is the hormone found when you're pregnant or have recently been pregnant. As far as whether or not it can be faked, those are issues where in order to fake or in order to get enough of that hormone in your body, you would have to ingest it and you would have to have a prescription to get that in our country. So I don't know exactly all the details of that, but it isn't necessarily a pregnancy test. And I don't believe that showed the results of the test. I'm not really sure. But either way, that's her argument.
Not your turn.
It is very questionable, as a woman who's been pregnant before, that Miss Owens goes to Banner to get an alleged pregnancy test on June 1st, and then she never goes back to Banner Health for any additional testing. The next page of this exhibit is simply a screenshot of an upcoming appointment with a Dr. McCool on Monday, July 24th, 2023. There are no records to support that she is an active patient with Dr. McCool, that he is her perinatalogist. There's nothing. We just have a screenshot of an appointment that was made, which anyone can do online. The next record, Your Honor, this is now a HCG test from any lab test now in Scottsdale. This is not a positive pregnancy test. This is a positive HCG test. Why is she going to a new provider for a alleged pregnancy test on October 16th? These next 2 pages of records, Your Honor, it's hard to tell what they are. They look like they are screen grabs of an appointment, but it's unclear. It's just unclear. At the root of this case, and the reason that Mr. Echard is fearful, he is scared, is the fact that there has been a fabricated pregnancy. She has participated in several paternity tests none of which have come back showing any proof or any signs of fetal DNA, Your Honor. If it wasn't for the fact that she has done this before in another case, this is unbelievable. It is very alarming. She lied under oath, and she lied under oath at the last hearing. She's not being truthful today, and my client is legitimately fearful of what else she's capable of. He's asking that this court recognize that he has done everything to handle this appropriately. He has begged and pleaded with her to stop contacting him. There is no reason for these two to have communication, despite what Ms. Owens will say regarding this alleged pregnancy. There is no proven pregnancy at this point. So we are asking that this court find that she has harassed Mr. Echard from May of 2023 up until today's date, and we're asking that the court find that the injunction against harassment needs to be ordered and maintained.
Clayton's lawyer, clear, firm, elegant, intellectual, really, I don't know what her price is, but worth the money here.
Thank you, Mr. Lopez.
Yes, Your Honor.
Okay, so now we go to Jane Doe's lawyer again. Maybe he's, let's listen.
Now, I would agree with Clayton that Laura's communications with him were alarming, annoying, harassing. If, in
Okay, good, fine. Wrap it up. I'm just kidding. No, that's
fact, Laura wasn't pregnant, and if, in fact, he wasn't responding to her through the over 4-month period that she's been pregnant. She is pregnant, and he has been responding.
pregnant with emotions.
Clayton has not met his burden in this matter. He's claimed that the amount of texts and emails has caused him to be alarmed, annoyed, harassed. Well, for starters, the reason there are so many emails and text messages is because the chosen form of communication between Laura and Clayton was through emails and text messages. And because that was how Clayton wanted them to communicate, not in person, not over the phone, but through emails and text messages. And second, we are talking about a span, again, of over 4 months or more. There are going to be a lot of text messages during that time. There are going to be a lot of emails during that time. Third, he claimed in his petition that he has not responded to Laura and that he had blocked her. Now, that is clearly a lie. And
I would object. That misstates the evidence. There is clear evidence to support that the messages are showing from a blocked sender. That is not accurate.
Your Honor, some of those messages may have been blocked. But there are other
Your Honor, yes, some of them were blocked. But oh my God, it reminds me of Pepe Le Pew, who just doesn't take no for an answer. You know what I mean?
Communications in the exhibits, in Clinton's own exhibits, that state, that show that he did respond to my client, whether it be in emails or text messages, and we've provided those some of those exhibits in the ones that were admitted to this court. Now, Laura testified that there was communication, even aside from the exhibits that we've presented. It's impossible to put all the communication within over 4 months into a short hearing, essentially. Now, I want to talk about the content.
And by the way,
of that.
that's what makes this so frustrating is this is a 1-2 hour long hearing, and there's so much information. And while Jane Doe's lawyer says it's hard to litigate it all because there's so much evidence and this and that, that's the point. If there was more time, I think there would be more exposing my opinions of the sort of fraud that's occurring here. Again, these are my opinions. I'm allowed to have them, folks.
Communication. All of the communication from my client to Clayton was meant for legitimate purposes and not to annoy him, not to harass him, not to alarm him. Almost all communication between Laura and Clayton was for the purposes of the pregnancy and paternity. The only other sort of communication from my client toward Clayton was in relation to the post that he put online when my client would receive harassing messages from Clayton's fans and his followers. So the communication around that time, call it August, September, was toward Clayton, asking him to take those different things down so that my client wouldn't be harassed. Throughout this entire time, since May, Clayton has never been clear with what he's wanted to do. He's been wishy-washy the entire time. First, he didn't believe that my client was pregnant, so she sent him proof, and she sent him proof again. He wanted numerous forms of proof. You saw in our exhibit the video of Miss Owens pregnant. That was a video that Clayton asked my client to send to him. How can you ask someone to send you proof of their pregnancy and then now call it harassment? Now say that you're alarmed. Now say that you're annoyed. Now say that you're harassed. That doesn't make any sense. He was also wishy-washy about what should be done with the unborn children. And we're talking about at the beginning, around May.
And my belief is this is due to gaslighting. If we are going to assume she isn't actually pregnant, again, this is just an assumption. This is my opinion based on the evidence I've seen. I believe in science, and part of believing in science is being able to question evidence. And if it can stand up to questioning, it would stand up to questioning if it was ultrasounds that had her name on them that were clearly from a medical provider. And while she'll continue to email me, and I'll continue to say, stop emailing me. I'll say that to her right now because we know she's watching. Stop emailing me. You know my lawyer's email address. You do not need to contact me. And as she'll continue to do that and continue to, violate my request, we just share our opinion that we don't believe she's pregnant. And if the evidence does come in that I'm wrong, I'll correct that. I'll even offer an apology, even though I will say, well, you'd have to understand there was a fraudulent ultrasound that clearly wasn't yours. There's repeat behavior. There's all these things that makes it hard for me to believe. So I'm steadfast in my opinion, and I'll continue to shout it for anyone who wants to listen. And I'm very, very confident that a court would agree with me that I have the right to share my opinion. We do live in the United States of America. My opinion doesn't send my audience out to harass her or to break into her house or all these insane allegations that get thrown my way. It is just me, a person sharing my opinion. We will remind our audience, don't Google her, don't look her up. The best thing you can do is pretend like she doesn't exist and just root on Clayton from just overcoming this horrendous, horrendous story and abuse of the court system. Again, my opinion.
June, should she have the children? Should they be aborted? Are we going to give them up for adoption? Am I going to have sole custody? Is she going to have sole custody? He was never consistent with what he wanted. I'm sure maybe he thought one thing one day and maybe he thought something else another day, and then he thought back to we didn't know what he wanted. And that was communication that was going both ways, back and forth between Clayton and Laura. Again, he hasn't been consistent, and that is what the root of this problem is. That is why there's so many communications back and forth. Had this been done in person, had they chosen to meet up physically or talk over the phone, things wouldn't get lost in translation.
Had he chosen, and I guess what he's saying is, had Clayton chosen to pursue a relationship with her, none of this would have happened. Now, I'm paraphrasing here. That's not what the lawyer's saying, but we do know she offered that to Clayton. I will give you the choice to decide what we do with this quote-unquote fetus or set of fetuses. I will give you that choice if we pursue this relationship. That was an offer she made to him.
Through email, through text. But that's how Clayton chose how he wanted communication with Laura. And that's what made everything so difficult. During this time period, Laura actually had to hire another attorney to help facilitate paternity testing. That didn't work, so then Laura had to file a matter out of the family court to create a parenting plan.
These are not facts and evidence at this time. These are exhibits that Mr. Lopez did not get to present.
I think she testified that she filed a paternity lawsuit.
And they did not have, neither of them, my client nor Clayton, have had an attorney in that family matter, so they are forced to communicate with each other because they needed to meet and confer. They needed to submit a resolution plan, so there's going to be text and communications back and forth from the two of them. Everything that you've heard during, whether it was our case in chief or the petitioner's case in chief, This is a snapshot of what has happened over the course of over 4 months. We were not able to present everything. All communication between my client and Clayton were for legitimate purposes. Again, not to harass him. Look at the exhibits. Look at the ones that Clayton submitted. There are clear exhibits that show that he was sending messages to her. We had submitted exhibits showing that Clayton had been communicating with her. So the fact that in the petition itself states that he had not responded to her, that's completely untrue. He had indicated in his petition that my client had harassed him. Well, that's not what happened. Who was the one that was posting videos online and getting harassed? Clayton was posting the videos. My client was getting harassed.
And Clayton's video didn't use her name. He just said he's got no fetal DNA proof that he's not the father, right? So this idea that we can link someone sharing their truth, someone sharing their thoughts online as harassment, we need to nip this shit in the bud. We need to nip this shit in the bud, because sharing your truth, whatever collateral damage comes from a comment section or somebody else, that is not harassment. It never has been. It never will be. There is no incitement by Clayton to harass her. That is not happening. If people online want to Google her or give her podcast a 1-star review, that's not his doing. He didn't enter this mud pit, coming after her. He's on the defensive.
Harassed. Not one communication. There wasn't one communication that indicated after they had been in communication since May. Since then, there was no communication
Get to it.
that were sent to my client, telling my client, stop texting me, stop emailing me, stop calling me. Not one. They presented one exhibit that shows one message that indicated that, I may call the police, something like that. It seems like he might be worried. But since then, he had been communicating with my client. So, again, you can't say that you are being alarmed, annoyed, harassed, but then going ahead and then emailing my client, texting my client.
What else you got?
And again, for all of those reasons, I think that the communication between my client and Mr. Echard were for legitimate purposes, for the to determine pregnancy itself, moving into determining paternity itself, to trying to schedule paternity testing with the attorney, to the family court matter, and to today. And so for all those reasons, we're requesting that this be dismissed. Thank you.
All right, time for the judge to decide.
In rebuttal, none of the communication
Oh, sorry, we're back to rebuttals.
from Ms. Owens to Clayton has been for a legitimate purpose. As the court has heard today, it is clear there has been no DNA test or test of any kind to support that she is allegedly pregnant with Mr. Echard's twins. There is no reason for these parties to communicate. What Mr. Lopez is proposing is that if you block someone, but they find another way to contact you, and then you tell them you still don't want to talk to them in a polite email or a polite message, then that's not harassment.
She's good.
That is the epitome of harassment, Your Honor. The court has received exhibits in the first hearing from Mr. Echard supporting that she would find other avenues to communicate with him after he had blocked her. Again, it is Mr. Echard's position that that this pregnancy has been fabricated. And I want to be clear on this, Your Honor. It's possible that Ms. Owens is pregnant, but it's my client's position that he did not have sexual intercourse with her, and she is not pregnant with his alleged twins. And that is the root of the issue here. There has been no support for this alleged pregnancy other than her attempts to show the court and or Mr. Echard a picture of her alleged pregnancy.
Yeah, that's what it comes down to. It's like no one's really saying she's not pregnant, although there would have been fetal DNA according to Clayton's test, and maybe the next test will show that. But there hasn't been any evidence to prove that she is Do you know what I mean? So there's that gray area where could she be pregnant? Yeah. But like no evidence other than appointments. And, we could just repeat this on and on.
Which, again, we suspect may still be fabricated. So there has been no legitimate purpose to her communication other than to harass Mr. Echard to try to force a relationship on him. She told Mr. Echard on multiple occasions that she was going to force him to communicate with her, whether he wanted to or not. And he has been clear. He does not want any additional communication from her.
All right, thank you. So, as I stated when we first started this hearing, I'm not making a determination as to whether or not she's pregnant or not. That is a family court matter. That case is pending before the family court. The testing or whatever is going to happen is a result of that. So I'm not making a decision and a determination today whether or not there is a valid or invalid pregnancy. I understand Mr. Echard's position is there isn't. I understand her position is there is. That's where we are at the moment. With regards to the evidence and the communication, the court at this time does find there were a series of events that were aimed at the plaintiff that would cause a reasonable person to be alarmed, annoyed, or harassed, that he was, in fact, alarmed, annoyed, or harassed. I do find they did not serve a legitimate purpose. Messages that have been sent, one, he blocked her on numerous occasions. She even said in the blocking communication, can you unblock me so I can unblock you again? I got a new number, and then there's another new number. I think that's clear that he does not wish to have communication. Nature of the communication, while maybe surrounds the pregnancy, the communications that I have a lot of concerns with are the ones where she's trying to make offers to him to continue a relationship, that she is trying to facilitate. If you do this, then I'll give you this. Those kinds of messages are of the nature that are harassing and can be viewed as alarming, annoying, or harassing. There are a number of messages that were admitted that are attempts at, I view kind of almost as trying to, get him to do and agree to things that are not necessarily, it's not like we said, hey, can you take a paternity test? And he said, no. Hey, can you reconsider? I want to do a paternity test. And then I went and filed a lawsuit because you wouldn't do it. I mean, that's one thing. 500 emails back and forth or messages, I'll say text messages and emails over that period of time to try to clarify and do that is beyond what was necessary to be able to communicate those things. There were a number of threats to go to the media, which were other additional attempts to try to use the media as manipulation or the threat to go to the media as manipulation. I find those to be alarming, annoying, or harassing. So I am going to grant the injunction at this time. The injunction is going to prevent any communication outside of the legal process, and specifically legal process and court hearings. So I am going to grant the injunction, and so I will sign the granted injunction today, and then I know Ms. Owens isn't present, but we can give a copy of the signed injunction, obviously, to Mr. Lopez today, but whether or not ultimately she needs to be served with it so that the service of the injunction is appropriate, because it will go into effect once the injunction is served upon her. It would remain in effect for a period of 1 year. This was the hearing that she had as a result of that, so there's not an additional time to request an additional hearing. And if you guys want to wait for a few minutes, I'll sign an order. If there were exhibits that you did not offer that you wish to have returned to you, you can let the clerk know and she can release those back.
Thank you.
Thank you.
Thank you.
Thank you.
There it is, folks. That's the order. The judge decides that a reasonable person would be alarmed at this series of events. He blocked her on numerous occasions. She got new numbers. It's clear he does not wish to have communication. The judge is concerned that she is facilitating demands, is harassing, and views this as alarming. 500 emails is beyond necessary. threats to go to the media, using the media as manipulation, and the judge then also finds that to be alarming. The injunction is granted to prevent any communication outside of the legal process, and the judge grants the injunction for a period of 1 year. There are your closing statements and the results that the judge has. We knew this from the end of the week, November 2nd, but we did not know, we weren't able to get the actual audio of that. The video is out there. I haven't seen it yet, but maybe we'll share it. Maybe we won't. We'll have to see how it all goes. We're covering this story. It's one of the most fascinating stories to cross Bachelor Nation ever, and it's also one of the most fascinating stories I've seen in the pop culture world in the last decade. And if there's any question as to why we're covering it, that should be the answer. I hope the GoFundMe will be restored. We're going to continue to raise money for our legal funds as we are continuing to receive threats of legal action. I believe we are in the right, and I appreciate all the support that we've had in covering this, and we won't be silenced specifically from sharing this truth as it is public and for all of us to consume and to look at and to see how the court process works. I hope you enjoyed this content. Do me a favor, follow me on Patreon if you want to put some bread in the tip jar, patreon.com/Dave Neal. We'll be live right after this.